Hello and welcome to Absolute Trust Talk. This is our live stream podcast at Absolute Trust Council. I am Kirsten Howe. I guess technically I'm the host today, but I have our associate Madison Gunn here with me, so we're kind of co-hosting today. Madison, I heard about this thing, COVID-19. Have you heard about
Just
that?
a little bit. I think I've heard a little bit about it.
I got information today that somebody we both know just got COVID. And then just after I heard that, a friend of mine texted me saying, my friend has COVID, and man, it's getting crazy.
Yeah. Getting to the unavoidable part, I think.
Well, I think people are starting to feel that way for sure. And I just hope it doesn't cause too much change in behavior. But anyway, that's what we have to deal with. So I hope if you're out there listening, you're staying safe. Don't get COVID just because you feel it's unavoidable. It is avoidable. Just don't get it.
And hopefully if you're listening, there's not like a COVID 45. So let's just hope that's
not right.
You're listening a couple years from now.
Yes. Okay. So today, we've been doing a few episodes on trust planning failures that show up after death, because we've been doing a lot of work with people who are trustees after somebody died, and we're just seeing these things. So we've done a number of episodes on those. Today, we're going to talk about estate planning failures, ideally with the intention of helping you avoid them, that show up when somebody is incapacitated. So, we know that people don't think about incapacity. They don't plan as carefully maybe for that as they do for their deaths, but it's important. And so we're going to talk about that today. And I think this will be helpful not only for those of you who are still alive and have capacity and can do planning, but it also is, some of this content is going to help our folks out there who are serving as trustees or agents under a power of attorney, because somebody is incapacitated now, and this will be helpful to them. So anyway, Madison, welcome. It's always good to have you here.
Thank you.
With me, because you fill in the gaps and you make me not look as stupid as I am. So we appreciate that. Now, one thing that I haven't done lately for a while, I guess, is remind our audience that we do take questions at the end. So if you're watching us live and you have a question, go ahead and type it in there and we will take your questions. If you're not watching us live, you're just listening after the fact or watching a video, I'm sorry, I can't answer your questions, but you can always send a question to us, info@absolutetrustcouncil.com, and we will figure out a way to get that answer back to you. Okay, so let's get started. I think we first have to get out of the way. What are we talking about when we use that term, incapacity? Madison, you want to get started on that?
Yeah, there's a couple different ways that somebody could be determined incapacitated. I mean, the big one is obviously if you have a court order. That can either be done through a conservatorship, or there are a couple other legal proceedings that can happen in order to get somebody declared incapacitated. It's all the same form through the court that a doctor fills out after they've seen somebody, saying that they're incapacitated, meaning they can't handle their financial affairs or they can't make medical decisions for themselves. It can run the whole gamut of incapacity if it's a court order.
A judge has said, yeah, this person has no capacity. Yeah.
And that goes, you have a whole process. They get their own attorney. They're interviewed by their own attorney. They're interviewed by a court investigator. They probably are interviewed by the judge. It's a lot. It's a lot.
Yeah. So. That's not usually what we are seeing.
No, usually the incapacity, the definition is determined by the definition in someone's trust or their power of attorney. Hopefully those definitions match if they have a power of attorney and a trust.
That's
sometimes
a good
they
point.
Don't, but hopefully they do. You don't have to jump through an extra set of hoops.
Yeah, we like to have only one set of flaming hoops to jump through to get that incapacity determination. And so the default I mean, what we see most often in documents that we read is if two doctors, or sometimes one doctor, if a doctor in writing says this person can't handle their financial affairs, then that's usually the definition that we're seeing in the documents. But it doesn't have to be that. And so we, oftentimes we will write something more customized, not the default. And Madison, I know you've written a number of these, we call it incapacity panel.
Yeah, sometimes people choose a group of friends that they want the majority or unanimous group to determine that they're incapacitated, or their children. I know sometimes that seems, counterintuitive to have your children decide when you're incapacitated, and then they turn around and handle all your finances. Obviously, that's only for people who have very good relationships with these people that they're naming on their incapacity panel. So that's important. Or they'll just limit it to one doctor. I mean, if you have a stroke and you're in the hospital, getting two doctors to sign off is not going to be difficult. But if you're starting to have cognitive impairment and dementia, that's when it's going to be hard, because you have good days, bad days, you can't predict. Your doctors spend 2 minutes with you, it's not.
Yeah. And getting somebody who is starting down that dementia pathway to agree to go to the doctor to be evaluated,
Right.
they might resist. And so we see that a lot. That is in my opinion, that is a big problem with having a doctor's determination be the requirement. It just can be hard for families to actually make that happen. And like you said, the doctor has about 2 minutes for you. They don't see what the family sees. They don't know that the dining room table is covered with unopened bills.
Right.
They just don't know all those things that close family members do know. So I guess the point here is you got to start by reading the documents. How do we know that we're in the realm of incapacity now? All right. So now the thing that triggered us, that we were having a conversation and made us think, we should do this episode because people don't know things, was a new law, well, relatively new. It was passed and effective this year, having to do with when a new trustee has to take over because the prior trustee has become, the prior trustee who was the grantor has become incapacitated. Madison, why don't you explain that law, because I'm kind of butchering it right now.
So it was Assembly Bill 1079 that was passed last year that amended Probate Code 15800. So previously, when somebody dies, that's the trustor of a trust or the creator of a trust. After, if it's one person, if it's single, both of them, if it's a spouse, you have to send out a notice to all the beneficiaries and heirs of the trust. That, that's a whole other topic that we've talked about, but that's what the law said. With the new change in the law, it says you have to do that also if everybody that has the power to revoke the trust is now incapacitated.
Right.
So if I have a trust and I have a stroke and I lose my capacity, that trust now essentially becomes irrevocable because I don't have the capacity to revoke my trust. So they, now they've extended it. But in addition to just notice, you now have to provide an accounting to all the beneficiaries of the trust who would be beneficiaries after the trustor dies.
After death. Yeah.
So, if you are incapacitated and your best friend is your trustee, they now have to provide an accounting to whoever you named in your trust, your kids, the other beneficiaries, you name it.
Yeah. And I think this is a good thing, because it used to be, prior to January, that if I became incapacitated and somebody had to step in and become my successor trustee, my family might not know about it. There's no reason why they would know.
They'd have to file a petition in the court to compel your trustee to provide an accounting, or, and usually they have to have some sort of evidence that they're doing something wrong.
Exactly. You've got to prove to a judge, I should be given this information. whereas under prior law, it really wasn't anybody's right. And so it's kind of, I think, protective of our, it's probably primarily directed at elder financial abuse, just to try to squash that as much as we can. I mean, we can't really, it's impossible, but that's one little area now where we have a little bit of sunlight.
Definitely something the California legislature is very gung-ho about, making sure that they're trying to protect all, put all the protections in place, I should say, for that they can.
Yeah, so I'm pleased with that. I'm pleased to see that. Okay, so our trustee now has to give notice. This person has now become incapacitated. So as a practical matter, the trust has become irrevocable, although legally it is still revocable.
Right.
And they've got to now provide accountings. So another thing about now you're the trustee, you've got to not only do that, but you really have to read and understand what your responsibilities are. You got to follow the law. You got to read the trust document. And that's just one law. That's just one little law that you've got to follow. There's so many laws in the world of trusts. You've got to understand, I mean, this is pretty basic, but you got to understand who are the beneficiaries. And this is one area where we do spend a lot of time planning with our clients. If you were incapacitated, we ask them this question. If you were incapacitated, is there anybody besides you that we need to know about? So like, what are some of the examples?
For example, if someone lives in your home with you, just because your daughter lives at home with you doesn't mean your trustee, who could be your brother, has to allow her to keep living there rent free, if you become incapacitated. So you have to put that language in your trust document. So assuming the house is going in the trust, because the house would be a trust asset. So that's a big one. If anyone's living at home, family, anybody that you can think of that would be living in your home with you, that you want that to be able to continue if you become incapacitated.
Yeah, because the trust, generally speaking, unless it specifically covers that issue, the trust will say, while I'm alive, I'm the only beneficiary of my trust. And so your successor trustee who takes over actually would not be allowed to let that person continue living in your home without charging them rent, unless you say so. So that's a really important point that I think a lot of people don't consider.
I think a lot of people just keep it all in the family and assume that everyone will do the right thing, and that that gets people in trouble.
I mean,
we all know.
You can imagine if, one sibling becomes the trustee and another sibling is living in the house for free. I mean, maybe they get along, but maybe the trustee sibling is going to say, you've been sponging off of mom long enough. Yeah. Now you're going to pay rent or get out. So,
yeah. Or what if mom needs to go into a facility and they have to make that house productive or sell it, and someone's living there, and now you have a sticky landlord-tenant situation, potentially. Sure. That's a whole other topic of whether someone's a tenant or not is a whole other conversation in the world of family members living with family members. But you just want to avoid it.
Right. The point is don't have that laying out there as a potential problem, because it's easily enough addressed in the planning. Or it doesn't even have to be living in your home. I mean, we have clients for sure who have rental properties and they rent to a family member. The rent is below market. Everybody knows it. But, the trustee who takes over, that's not okay unless the trust says it's okay to rent below market to this person. So, the trustee's legal duty would be to make that rent fair market rent.
Right.
So
same as if, your husband pays $1,000 a month for his mom's care. If your husband becomes incapacitated and the trust doesn't say anything, there's no legal obligation to pay for your mother-in-law's care or your grandma's care or whatever the case may be.
Right.
So if you are financially supporting somebody and you want that financial support to continue, if you become incapacitated, then that needs to be in there too.
Right. And so, like I said, the flip side of all of this is if you are the trustee and you've got, a grandma who's dependent upon your grantor, or you got someone living in the grantor's house, you need to take a good look at that document and figure out what it allows you to do and what it doesn't say. And you're going to have to sort that out. It's not that there's no solution there. If everybody wants the sister to continue living in the house, but the trust doesn't say that, there's a solution, but you just have to be paying attention because, our job is to protect the trustee. We don't want them to get in trouble.
Yeah. You don't want the other beneficiaries to all of a sudden be like, you were spending money on what? Where did you get the authorization to do that?
Where does it say you can do that?
Yeah.
Yeah. Okay. So, well, and another thing that we sometimes need to build into a trust that isn't usually in the trust unless we specifically want it in there is gifting powers, because the trust assets are there for the benefit of the client. Now the client's incapacitated. We can't give money away unless it's authorized. So that could be to friends, family members. It can also be to charities. Sometimes our clients are charitably inclined. They regularly give to a charity and they would want that to continue. So the trust has to say that.
Yeah. If tithing is important to you, you should make sure that that's in your trust.
Right. Yeah. Or even something like, you're a sustaining member of KQED.
Yes. I knew you were going to throw that in there.
I'm just thinking about my checking account.
Or the Oakland Animal Society. Or the
there you go.
Yeah.
Yeah.
Shout out to Reese, who's the star of this podcast.
I know. Sorry.
No apologies.
Reese is our co-star in my background. If you were paying careful attention, those of you listening to the audio podcast, you missed out on that. Okay, so we've been talking about trust now, but the other place where incapacity comes up is in the powers of attorney. There she is, which all of our clients should have. All people over the age of 18 should have a power of attorney for legal and financial matters. And we run into problems. We see clients running into problems with these. It's not uncommon. Unfortunately. You want to talk a little bit about some of those problems that we see?
Yeah, the big ones are that banks just like to say no. I think that's the biggest thing is banks are
power of attorney, schmower of attorney.
Yeah, pretty much. They're like, that's not on our letterhead, or that's from last year. What's the problem with that? We used to say if it's 10 years old, you should probably update it. The banks are like, that was 2020. That's that's totally not right. And we're like, but there is there are tools you can use to make them accept your power of attorney. So that doesn't mean that you have to execute a new power of attorney every month. Obviously, that's not viable. If someone executed their power of attorney in 2020 and they're now incapacitated, they can't just go execute a new one.
You can't go do a new one. Yeah.
Although the banks seem to think they can, but they can't.
Right. So, yeah. So, the point there is an old power of attorney is still valid.
Yeah.
There's nothing in the law or in the document that says this expires in 10 years or 5 years or whatever. It's just that we are at the mercy of the financial institution, whether they're going to choose to accept it or not. And so, one thing to think about is keeping it a little fresh. If you do have a 10-year-old power of attorney, go back to your attorney and say, let's just freshen this up right now.
You might want to see what powers are good for you too. 10 years ago, you might not have had something in there that might be pertinent now.
Yes.
Like, there are certain things like dealing with your business or things of that nature that might not have mattered to you 10 years ago, but it might matter now.
Correct.
So
Yeah, it's always good to re-examine those powers. And also the agents, you know, do I still trust this person?
Yeah.
Do I still like this person? But they definitely push back by saying it's too old. We do see that, even though their definition of old and ours is not really aligned. They also, now I've been hearing a lot of times they don't want to see multiple agents. They will just say, no, we can't accept this. If you've got two people acting as your agent under a power of attorney at the same time, we can't deal with that. The financial institutions will push back.
Yeah, I've been seeing that. Not so much like access, like they can't deny the access, but like moving forward. So it's almost like you have to pull all the money out and find a bank that will take
accept
multiple, which, you know, that as a power of attorney or a successor trustee, you get to choose the bank.
Yeah,
That's convenient for you. You don't have to keep, you know, if mom had a 30-year relationship with the bank and they don't view that as a relationship with you, why should you stay there? You know, but with multiple agents, which we don't highly encourage anybody.
We don't recommend.
They do require both of you to be there in person to sign everything. And if your trust, you know, you could probably fight it. You have the trust should say that one can act without the other or things like that, but you've got to get it up to the bank's legal department. You have to assume they know what they're doing. You have, you know, and all of these things and hope that they do the right thing. And, you know, who wants to set that fight up when you're just trying to access the money to pay mom's PG&E bill?
Yeah. Yeah. And, you know, when you're dealing with the bank, you're dealing with someone at the branch level, as you pointed out, has not necessarily been trained on how to deal with powers of attorney.
Even just going to put your trust in your account into your trust is something that's difficult. And I think that it's all about who you get. So, I mean, as funny, as weird as we've gotten farther away from this, it's almost more important than ever is that you should probably have a relationship with somebody at your bank. That would make your life a lot easier.
Oh, for sure. Yeah.
You know, I know that's hard now because all of our bank branches were closed due to that you know, whole COVID thing. But they, you know, it's hard. It's hard to get stuff done with like this.
Right. So that's a good point. If there's any way to cultivate a relationship with your bank, with your financial institution, you know, your brokerage, that's one way to go. That's one way to kind of smooth these things out. And so the other thing that I always talk to clients about is, you know, one way to completely avoid all of this is to use the bank or the brokerage house's own power of attorney form, because a lot of them, the big institutions, they have their own power of attorney form.
Yeah.
And so, yeah, you're going to have the power of attorney that your lawyer wrote for you, and also you can use their form, and they have that in your file. They can't say no to that because they can't say that's not adequate.
Right.
They can't push back on it. It's their form. So that's a really good idea, I think. If you have the time and the energy to go around to your banks and your financial institution, just ask them, do you have a power of attorney form?
It's also really important to make sure that the agents match. If you have a drafted power of attorney and then you fill out one at the bank, you don't want them to conflict with each other.
True. Yeah.
Just in case people don't get along, because then you might run into it.
Right. That's right. That's right. That's a really good point. I hadn't really thought about that. And I guess the big another big way to get around that problem of banks not accepting your power of attorney is just put the bank account in your trust. It's a lot easier to get a bank to accept a successor trustee. That's been our experience anyway.
It's already in the
trust. Try and push on a power of attorney that they don't want, that, you know, they're holding their nose. So that's always good advice. Put all your assets in your trust.
Yeah, you don't really want people have to be juggling your certificate of trust and your power of attorney. and all the different banks' powers of attorney and things like that, just to try and get you on bill pay and get, everything taken care of. It's, it's already, being a trustee is already a fairly big enough hassle, and so if it's not all set up properly, then it's, even worse.
Right. Okay. So let's look to our questions. We do have some audience questions. I'm just scrolling up, trying not to miss any. Okay. So there we go. We have a question. Okay. So this is kind of what we were just talking about. Can you have more than one power of attorney? Yeah. So the answer is yes. I would say, one important thing is that I think they should reference each other. To the extent you can. So our attorney drafted powers of attorney, they're general powers of attorney. They're meant to cover all kinds of things. The one you fill out at your bank, it's only relative to that bank.
Right.
And the accounts that you have at that bank, it doesn't give anybody the authority to call PG&E and complain about, whatever. But in our general powers of attorney, we always say, I don't have any other powers of attorney except I might have financial institution powers of attorney, and those are still valid. So I think it's important to reference those.
Yeah. Or if you have a power of attorney for your business, sometimes those are very specific powers of attorney. Or like for us, our spouses or our kids can't be our power of attorney for our legal matters. So you have to name somebody else. So that would all be referenced in your general power of attorney as well.
Right. Yeah. In your general power of attorney, you want to also say, and by the way, I have these other powers of attorney out there, and that's okay.
Yeah.
Okay. So let's see. Next question. What do you recommend doing if a bank refuses to honor a power of attorney?
Okay. Well,
good at.
I know this one. Kind of there is a probate code section. I don't know the number off the top of my head, but there is a probate code section that if a bank refuses to honor a power of attorney and you take them to court because the law says they have to, then they have to pay your legal fees for taking them to court. So usually if you just show them that probate code, they'll just roll over. I mean, particularly if if whose assets you're trying to access is already incapacitated, because at that point you can't just have them fill out their own power of attorney at
There's
the
no
bank.
alternative.
Yeah. Otherwise, I would just say have the, if it's mom or dad and they're still okay, you don't have to take them to the bank to have them fill out the bank's power of attorney form. They'll print it for you. You can fill it out, sign it with a notary, use a mobile notary, whatever, and then send it back. I know when COVID first happened, the law says you don't have to have a power of attorney notarized, but you're going to have to be threatening the bank with that probate code section every single time because they're going to want it notarized. Right. So, I mean, sometimes it's just easier to play by the rules a little bit. The bank's rules a little bit. It just makes things a lot smoother.
Right. The law says it can be notarized or witnessed.
Right.
But they're not happy with a witnessed document. Yeah. So you can fight back, and usually without going to court, we can get the banks to back down if you just talk to them the right way. And sometimes it means escalating it up to their legal department. But I
think the first line is always just to ask for someone else. No offense, but just ask for, to that person. But just
supervisor.
Yeah.
So. Just push it up a little higher. Okay. So I think I have one more question. If someone has been serving as trustee for the past few years for a parent, because the parent no longer has capacity, do they need to give that trustee notice now?
I don't think they need to give the trustee notice if they became incapacitated prior to January 1st, 2022, but you would need to start complying with the accounting requirement.
Yeah, I think you're right. When I read the statutes, the code sections, I don't see that there's now a requirement to go back and give that trustee notice, but it does require ongoing accounting. So you do want to comply with that. Yeah. All right. I'm going to scroll down and just make sure I'm not missing any other questions, because sometimes I do that and then I feel bad afterwards. Okay, that's it. It looks like that's all our questions. So, Madison, this is fun. You have any final parting words?
No, I mean, stay healthy, wear a mask, update your power of attorney.
And update your power of attorney, please.
Make sure everything's in your trust. I mean, I feel like we could do that topic every other week. Make sure everything's in your trust.
Yeah.
I mean, it sounds easier, but it sounds easy enough, but we know from experience that that's not necessarily,
as with most things, we procrastinate. That's what humans do. And so we don't take care of those little details and loose ends, but it can come back to bite you or your family. So just do it. Just do it.
It's a lot easier to plan while people have capacity than to deal with it when they've lost capacity. So
yeah, that's very hard and frustrating. All right. Well, thank you all for joining us here today. I hope you got a lot out of that. I did. That was an interesting conversation. And we look forward to connecting with you next time.
Thank you for joining us today for another episode of Absolute Trust Talk Live. If you enjoyed listening in, then don't forget to subscribe. You can find us on Apple Podcasts or wherever you may listen by searching Absolute Trust Talk. While you're there, we would also love for you to leave us a review. And then why not share your favorite episodes with family, friends, or colleagues too? You can find all of our shows and corresponding show notes by visiting absolutetrustcouncil.com. You'll also find a variety of other free resources, including our ebooks, videos, blogs, presentations, and more. If you need help with your estate planning or administration, we also offer a free discovery call to help get the process started. You can find more information on booking your session by visiting absolutetrustcouncil.com/scheduling. Don't forget to keep an eye out for our next live episode in 2 weeks. If you join us for the broadcast, you can submit questions during the show. But if not, don't worry. You can always get in touch with us by sending a quick message to info@absolutetrustcouncil.com. Thanks again for listening. We'll see you soon.